Dear friends, this is Advocate Nedumpara. I'm sorry I couldn't conclude my friend's other case query as the performance of Justice Chandrachud as CJI for the last 1 year in the last two videos. So let me conclude this in this video, and my assessment of the situation is Justice Chandrachud, despite all his lordship's good intentions, could not do much substantially on the question of being the Supreme Court being truly a court of the Supreme Court where the ordinary people can assuredly see and seek justice. The reason I say so is because the court is face a conflicting considerations. On one hand, the pressure which is mounted on it by PALs, and another is the ever increasing demand for constitutional benches. See, if a constitutional bench of 5 judges is constituted, then that would mean breaking of many other benches. So normally Supreme Court function as benches of 2 and 3 judges. Most of the benches are 2 judge benches. If a constitutional bench of 7 judges has to be constituted, that will literally mean the complete breakdown of the normal functioning of the Supreme Court. And this clamor for the constitution of the creation of the constitution of constitutional benches has no foundation in jurisprudence. See, the court job is not to enact law. The court's job is to interpret law. And to interpret law, that interpretation given to a particular case, that is binding between the parties and not others. If a principle is evolved in a case between A and B, and that principle can be applied as a precedent in a subsequent case. And what is determinative is the validity of the reason. So the concept of ratio decidendi, reason for the judgment. So if the principle is what is a precedent and what is binding as a precedent is a principle. Now this concept has been completely misunderstood, and now a new concept, and it has been so stated in Andali's case, paragraph 44, I think, if my memory is right, that we don't follow the pristine concept of jurisprudence that what is a precedent is a principle, and the number of the strength of the bench, or even that has no value. And only that matters is the principle. Now, what we follow today, which in Andre's case it has been stated, that the presidential value of a judgment is determined based on the strength of the bench. So this is something against basic principles of jurisprudence, against reason. And if this wrong practice, if allowed to be continued, then a day will become, then Supreme Court will become non-functional. Because look at the Supreme Court, it is under Article 136. An appeal will lie. A citizen has a right to can seek a leave to appeal from any order of any court or tribunal. And under Article 30, the Article 136 is certainly an absolute need. Look at the Bombay High Court. Against a judgment of a division bench on the original side, there is no appeal. There's no statute doesn't provide for an appeal. The only forum open is in SLP under 136. So therefore, the practice of constitutional benches to settle legal propositions, settle law, that has to be revisited. Then the other question is the question of the Supreme Court today. Sometimes lawyers say they call family court. So that's a reality. Look at the composition of the Supreme Court for last so many years. So therefore, this is an area where I may have, and we ordinary lawyers, first generation lawyers, common lawyers, and the public at large have certainly a perceptual difference between the Chief Justice of India. The reason here, there is hardly any representation of the first generation lawyers. Even we talk about Justice Muralidhar. Muralidhar is one of the finest of judges the country has ever seen. But Muralidhar could reach that position because he was a junior Parasaran. So whoever you take, whoever has become the Supreme Chief Justice of the India or Chief Justice of High Courts or the senior judges of the Supreme Court, there was somebody as a godfather. Somebody there to help them to climb up the ladder. So this scenario has to change. A Supreme Court has to be truly a democratic institution, and the office of the judge is a public office. And every eligible lawyer and from every part of this country should have an equal opportunity. So Article 14 is the core of our constitution, that is equality, equal opportunities, equality before law, equal protection of law. And when it comes to the appointments to the Supreme Court, judicial appointments, Article 14 is completely violated. There is a denial of opportunities for the sons and daughters of ordinary people. And this is an issue which I would certainly expect the Honorable Chief Justice to look into, in which case, which is not possible except by abolishing collegium. So long as collegiate system remains, it is impossible. And what is to be done is to, we have to advertise the vacancies of the judges of the High Court, invite applications, and then there are many lawyers who are very competent, eligible, deserving. They are practicing the offices, they are practicing district courts. And all those people, they should be given an opportunity. And when vacancies are advertised, then it will bring to an end to the allegation that judges' elections, judges are appointed on a telephone call. It is not what I say. The former judge of the Bombay High Court told me, Nedumpara, see, look here, judges are appointed on a telephone call. So therefore this is something undeniable. That is what to be immediately looked into, abolishment of collegium. And now the other thing, designation system. That has to go. The Farid Nariman says it is amounted to casteism. Right? It is even worse. It is apartheid. You have to, in a radial system, in a constitutional democracy, at least litigants and lawyers be treated, all should be treated fairly and equally. The scenario here is undeniable. The sons of judges, senior lawyers, they are given a preferential treatment. Even the board is discharged, they are heard for hours. It is not that I complain about it. It is talk to me. There are many young lawyers, they come to me, they talk to me, they complain to me. And not that because I have any authority, because as a person, as an elder member of the bar, they come to me and they express their anguish. Now, this is some area. Therefore, the solution is to bring about radical changes. Now, then again, even in the institution has to work. Look at the Bombay High Court. 2012 cases, petition filed in 2012 is not even listed today. Only those cases which are mentioned are alone heard, and matters which are mentioned when a senior lawyer or prominent lawyer mentioned, the matter is listed on the supplementary list, it is heard. Other cases are listed, it is not heard. So therefore, if the concept of access to justice to become real, the cases has to be listed. The cases of the lawyer of least consequences or the litigant of least consequences, that has to require to be listed and heard. And therefore, then it requires the largest strength in the High Court. And for Article 32 to work, You need a Supreme Court of 1,000 judges. If everybody could be allowed to come to the Supreme Court for enforcement of their fundamental rights. So that is not the solution. The solution is to strengthen the civil court. The Supreme Court is not the true constitutional court. Supreme Court is a court of appeal, final court of appeal, deciding constitutional matters. The constitutional court in our constitutional scheme is the ordinary civil court. That was the case before the constitution came into existence. And the power to declare even an act of parliament is unconstitutional. Even before the constitution, it was still in the ordinary civil court. It continues to be there in the ordinary civil court. So Article 32 and 226 actually was, those provisions were incorporated without without a real thought of the consequence it will lead to. Thank you. I cannot continue further, and I would request all of you to share these videos. And certainly many people would be disagreeing with me. I would like to hear the disagreement, the criticism. Thank you all, and I wish Justice Chandrachud a happy birthday and all prosperous New Year.